Hello, everybody. Welcome to Homeline's May installment of our ongoing webinar series on Minnesota tenant landlord law. Today, we have a very exciting webinar about changes in eviction laws and how they are impacting our housing courts. So we're going to head and we'll get started here in just about a minute. We got lots of interesting things to cover today. But I want to make sure that we give people time to get in. The session is being recorded, so you are aware. And let's see, we are coming through here. It looks like we are, according to my clock, just at 1:30 now. So kudos to you all who have shown up on time. Well done. You get the full experience. Because we have so much to do today to get through, I want to go ahead and make sure that we get started here. So again, everyone, thank you very much for joining us today. This is Homeline's May webinar. We're going to be having a couple of folks from the judiciary cover the changes that the new eviction laws that went into effect January 1st of this year, how those changes are kind of impacting their courtrooms and the court procedures in general, and just giving us an overview from that perspective. So we will have referee Tiffany Cedios, who is a referee in Hennepin County. And then we will also have Elizabeth Wendt, who is legal counsel for in the judicial branch. So before we get started with that, just a couple of quick housekeeping things from my end. Homeline, in case you're new here, we've been doing these webinars for, well, since April of 2020, really. But at this point, we have, we as Homeline is a nonprofit. We help tenants across the state of Minnesota kind of navigate what their rights are under Minnesota tenant landlord law. We have helped over 315,000 renters since opening in 1992. And we offer our services in 4 languages: English, Somali, Hmong, as well as Spanish. That's the 4th one. And we also have an email and attorney option that you can use if that's your preference. And all that information is on here. You can go to our website, homelinemn.org. Upcoming webinars. Like I was saying, we do these once a month. And so next month, we are going to be covering the 2024 legislative session recap. So what has happened in regards to tenant landlord law this session. The session itself is wrapping up technically this next Monday. So I will be scrambling the rest of May and into June to get all of that sorted out. And we'll be joined by our policy director, Michael Dahl, and policy attorney, Larry McDonough. July 17th, we will be again focusing on evictions, but we're going to be doing eviction filing statistics is kind of what we've been seeing for the last year. That'll be on July 17th. More info to come. You can register by going to our website, homelinemn.org, and following the appropriate links. All right, housekeeping as promised. So like I said, this session is being recorded. It will be available on our website after this, usually within a day or two, depending on how long it takes us to get it off the cloud. If you have questions, which we encourage you to do, we will have time for questions at the end of this. Please use the Q&A function that is going to be at the bottom of your Zoom screen. I will be posting links and things in the chat that you can access, but it also means that I probably am going to miss a question that is put into the chat. So please, 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 please use the Q&A function so that I don't miss your question. We will be applying for 1.5 CLE credits for this after the fact, presuming that we take all 90 minutes of this. So keep an eye out. We will email you with the CLE code once we get that. All right. I am done. So I'm going to turn it over to our lovely guests here today to take it through. Thank you all very much for being here and sharing your information. Appreciate it. Referee Studios, I cannot hear you now. I'm sorry.
Oh,
Oh, there
that's
you
not.
are. There we go.
You got me?
Yes.
Yeah.
Okay, sorry about.
Oh,
You cut out again.
you cut out again. I'm sorry. I don't know if there's a connection issue or what have you. Nope. Um, well,
If you want
this
me
is always
to
fun.
to
Yeah,
start,
if
I
you want to
can.
start,
Referee
that would be
Studios.
great.
Okay,
I'll let you all get into it. I'm going to start posting links in the chat.
great, thanks. And Referee Studios, feel free to chime in if it starts working or if you want to test it again.
I think it's working. Is it
Yeah,
working?
yeah.
Okay. Okay, great. Sorry about that. Okay. Well,
Go
I was
ahead.
just saying, good afternoon, everybody. I'm Referee Studios. I work in the 4th Judicial District in Housing Court, and I'm super excited to be here today. So, we're going to go through some slides today about how changes to the eviction laws are impacting the courts. I'm sure if you're here today, it's because you have some interest in housing law, so you probably already know a lot of these changes took effect on January 1st of this year. And there has been quite a bit significant changes. So we're going to talk about those and talk about a little bit about sort of the statistics about what's going on at the courts. And with that, um, Elizabeth, I missed whatever you said. I'm sure it was brilliant. And
I didn't say anything yet,
oh,
actually.
you did.
Yeah.
Okay.
I Hi everybody. I'm Elizabeth. I work at the Legal Counsel Division for the State Court Administrator's Office, and I used to work more closely with Referee Studios in the 4th District as a staff attorney there. And before we get started on the roadmap of legislative changes, we thought we'd share some interesting statistics with the group. So Rachel, if you can go to the next slide, and then one more. This is just a graph that shows the filing trends in the 4th Judicial District specifically. As you can see, there was quite a spike in March of this year and March of last year. I would say referee sales, probably in a 10-year period, average filings are between 450 and 550. So the fact that they've practically doubled is quite a big resource strain on the 4th Judicial Districts. And this filing trend is similar statewide as well.
Yeah, I would agree. I mean, you can see from the chart really since the eviction moratorium sort of lifted and things started sort of moving again back in 2022. Um, it has been a busy time for the housing court and in the 4th. This is just so everybody understands. This is a count of the cases filed in housing court only. And so the darkest blue line, which is on your screen, shows this year we had a big drop in January. And we have some ideas about why that might be. But then we sort of level off around the 750, 800 mark per month. So those are new filings that occur every month.
And then the state did receive special funding for hiring temporary judicial officers to help process the cases. That funding is in the expiration stage, so we are going to lose some of the referees we have now if we haven't already by June. So that's just another thing to keep in mind with the volume in housing court. Next slide, please. This graph, I don't know why it showed jumbled up at the bottom, but the bottom there is it shows the month and the year, but this is a visual of what we call the backlog. So the pandemic stalled operations not only for private companies but for government entities as well as us, why we figured out how to transition everything online. And in response to that, we had a backload of criminal and non-criminal cases. We officially this week have completed the criminal backlog. And you can see here that the non-criminal backlog is in good shape too. Not sure. I talked to research about the recent spike. The very end there is March of this year. It might be due to sometimes you get kind of mass lawsuits, civil actions, or we get consolidated lawsuits. That might be it, but otherwise I don't have quite an explanation. But the reason why this is helpful for this team is that the criminal backlog took precedent during the tail end of the pandemic. And that meant that a lot of the judicial and administrative resources were dedicated to criminal, and folks might have seen that their civil trials took a little bit longer. But what this graph shows is that we're in a really good spot and things are operating pretty smoothly now. And then the next slide is specific to the eviction caseload and that backlog. And that peak, I have the peak you could imagine was from March 2022 to March 2023, that high peak there, which coincides with the pandemic, vaccines becoming available, and some of the protections for not evicting tenants were being sunsetted, and then there was an eviction filing peak. And the next slide is just a roadmap of what we're going to be talking about today. We're going to spend time talking about public access to eviction actions, how the statutes and the rules interplay, the eviction complaint content changes according to statutory changes, trials and scheduling, expungements, court-appointed attorneys, and then emergency tenant remedy actions. So I'll start out with talking a little bit about public access to eviction records. During the 2023 session laws, the legislature passed a section within Chapter 504B that stated that eviction actions would not be accessible to the public until a final judgment is entered in the record. The Supreme Court issued an order a few months after that session law was passed to clarify that court rules govern access to court records and not the statute. So eviction actions are accessible to the public even when they're pending, unless a court order provides otherwise. And then I'll turn it over to Tiffany for the next couple slides.
Okay. So this next slide talks about some of the changes with regards to eviction complaints. So starting January 1st, there were significant changes in the law regarding what needs to be given to tenants prior to filing an eviction complaint. So one of those things is a 14-day pre-filing notice. Prior to this, there were some cities that had ordinances requiring certain kinds of notices. Minneapolis had a 14-day notice, St. Louis Park had a 7-day notice, and Brooklyn Center had a 30-day notice requirement. And those are still in effect, but there's also now a statewide 14-day pre-filing notice requirement. This notice has to have some specific language as required by the statute. It has to include the total amount due, a specific accounting, the name and address of the person authorized to receive rent, and then the 3 following statements, which you can read on your screen here, but essentially giving tenants information about where they can seek legal help, financial assistance, and also information that their landlord would be able to file an eviction case if they do not pay the amount due or move out within 14 days from the date of the notice. So that's a new change for January 1st and a big change for the courts. And if we go to the next slide, we'll see that part of the reason the 14-day notice is a big change for the courts is because it now has to be attached. You'll see on the second bulleted point down that the 14-day notice, if it's a non-payment case, has to be attached to the complaint when it's filed with the courts. And then there's a long list of other things depending on the type of eviction case that's being filed. So this is new also for January 1st. If you are a landlord and you're wanting to evict a tenant who has a written lease agreement, you have to attach a copy of that written lease agreement to your complaint along with any addendum that's attached to that lease agreement. As I said before, if it's a non-payment case, you have to attach that 14-day notice that I just described in the last slide, along with a ledger, otherwise known as a detailed itemized accounting or statement listing the amounts owed and the amounts paid. We call that a ledger for shorthand. If it's a breach of lease case, in the complaint, the landlord needs to identify the clause of the lease that is being breached, the nature of the conduct, the dates of the conduct, and the clause in the lease that's granting the right to evict based on the conduct. If there's a violation of Minnesota statute 504B.171, which is the I shorthand it to say the illegal things. So if someone is manufacturing drugs, or they're engaging in prostitution, or lots of other things that are on the list of criminal conduct that would result in a breach of the covenants, you have to state the specific nature of the conduct and the dates on which that conduct occurred in your complaint if you're a landlord. If you are filing an eviction case for a holdover, which is when a lease has been canceled or ends and a new lease hasn't begun, then we call that a holdover, and you would need to attach a copy of the notice to quit or notice to vacate that was given to the tenant. And then you also have to state in your complaint, if you're a landlord, whether the tenancy is affected by any federal or state housing subsidy program. And so those are some of the biggest changes with regards to filing a complaint. And then I think probably for the court's purposes anyway, the biggest change for us is that if any of these things are missing, the statute says that the court must dismiss and expunge the record of any action if the person bringing the complaint failed to comply with any of the requirements in the Minnesota statute 504B.321. So, right at the beginning of the year and even into present day, we're still seeing a lot of cases getting dismissed because of a lack of one or many of these requirements. It has gotten a little bit, I would say, more confusing for people that are filing eviction cases on what they're supposed to attach or include. And so that has had a big impact on the courts at this time. The next slide talks about scheduling of trials. That's also been a big change for housing courts. So there used to be a time sort of requirement on how soon a trial had to occur in a housing case. But now the statute has been sort of broadened to allow for a trial to occur on sort of whatever date is necessary based on the merits of the case, the complexity of the case, discovery that's needed, making sure the witnesses can appear and things of that nature. So that's a big change. We used to be, a lot more concerned about getting a trial within, 14 days, but now the statute has changed, so we can basically set it for whenever is feasible based on the type of case that we have in front of us. Additionally, another big change about trials scheduling is with regards to payment of rent. It used to be that pretty frequently, I would say, people would be required to pay rent into court pending their trial. And if the payments weren't made into court, then the case, a judgment would enter in the case and the trial would not occur. The rule or the statute on that has changed significantly. It says now that the court may not require the tenant to pay any amount of money into court, post a bond, or make a payment directly to a landlord, or by any other means post security, which basically means money, except if the final disposition of the case would be delayed by more than 10 days, which, if you sort of combine this with the statute above, you can see that probably more than likely the case will be delayed by more than 10 days. So this often applies, at least here in the 4th. I know that it's different in different districts, but in Hennepin County, most of our cases are delayed by more than 10 days, which means that we can order the defendant, which is the tenant in this scenario, to provide a security in a form that the court approves based on the totality of the circumstances. However, the amount can't include any amounts that were allegedly owed prior to the date of filing of the case, and may not exceed the amount of the monthly rent that accrues during the pendency of the case. So what that change means is that if we are ordering a tenant to deposit rent on a non-payment case into court, we can't, even if the allegation is that they haven't paid rent for 6 months, we wouldn't be able to require the tenant to pay that 6 months of back rent into court. immediately. It would be just whatever rent accrues going forward based on whenever the trial is going to be scheduled. Another, if we go to the next slide, another big change has been to expungements. If you're in this world where you're working with landlord-tenant type cases, you are aware of this, I'm sure. Expungements was one of the very big changes that the legislature made. They've kind of separated expungements into two separate categories. There's one category of expungements where there's no motion required, and then there's another category where motions are required. So the categories in which no motion is required to expunge a case are cases where the tenant has prevailed on the merits of the case has been dismissed for any reason, the parties have agreed to the expungement, 3 years have passed since the entry of the eviction judgment, or in a contract for deed or foreclosure case, if the defendant vacated the property prior to the filing of the case, or the defendant was a tenant and did not receive notice to vacate prior to the commencement of the case. Sort of the significance of that is that what we're seeing a lot of now, at least in the fourth, is requests to expunge cases that are not motions, which based on this list and this new statute is fine. And so we get lots and lots of requests every day for expungements that are either older than 3 years, or if the parties have agreed to the expungement, we see a lot of those as well. Or if the case has been dismissed for any reason. So I would say those are the three biggest ones that we see right now, at least in the fourth. And then there's still some types of expungements that require a motion. If the case settled and then the tenant does fulfill the terms of the settlement agreement, a motion would be required. Or if it was based on any kind of cannabis-related crime. I have actually not seen any of those come through yet, but if they did come through, they would come through in the form of a motion, a written motion. So next slide.
And I can take this slide. This is explaining the particular provision about 3 years post an eviction judgment. So the 2023 session laws and the list included in the prior slide include that the court shall order the expungement of an eviction granted 3 years or more. And it was quickly realized that there was going to be confusion from court users on how this was going to be applied. And legislation is interpreted as a go-forward basis unless expressly and clearly intended otherwise by the legislature. Unlike the cannabis eviction laws that were clearly retroactive, this law was not. So the courts aren't applying a global expungement process because this is a go-forward basis. So it would be 3 years from an eviction granted January 1 or later. This particular law also requires a court order in each case. So it says the court shall order. The cannabis expungement law doesn't require an order. It's an automated process. There is pending legislation in the current session that would make this 3-year expungement provision retroactive. Last I was following was that there wasn't a conference committee scheduled. So everybody can keep an eye out on that piece of legislation. Rachel, if you don't have the bill number, I could send it to you so you can put it in the chat. So there isn't a magic wand that's happening that on January 1st, anything that was 3 years or older is going away. We do have a retention schedule that is accessible online, and the link is in this PowerPoint. And that has a list of cases, their documents, their exhibits, and how long the courts retain them. So there is a destruction process where, according to that schedule, state court administration will destroy cases if it meets that deadline. And that means that the case isn't accessible to the public. In fact, there's no documents available ever again for those particular cases that are destroyed. A lot of the destruction project was placed on hold during the pandemic, and those areas are getting reconstituted. And the retention schedule currently has only 1 year for evictions. That timeline might be revisited, but it's quite possible that eviction actions will get destroyed. Either pursuant to the retention schedule, or if the legislature enacts the law retroactively in this current session, that you'll start seeing some of those cases inaccessible to the public. Next slide. Would you like to take this one, Referee CDOs?
Sure. And so this is kind of just continue more information about expungements. In addition to the statutory language that we have in 484.014, we also have what's called discretionary expungements or inherent authority expungements. So under the discretionary category, it's basically if the court finds that expungement is clearly in the interest of justice and those interests are not outweighed by the public interest in knowing about the record. In that situation, the court can expunge a matter. Additionally, district courts have the inherent authority to expunge judicially held eviction records after applying a balancing test. And so those are pre this year, but those continue on. And then we just, I think, have a little explanation about the difference between expungements versus sealing a record. And this is a question that we get quite frequently. Expungement is a legislative creature and is limited to evictions and housing cases. However, district courts have the inherent authority to seal other case records pursuant to the common law. And there's a case cited there that talks about the ability of the courts to seal records. So essentially, the outcome is the same. It's just sort of how you get there that's different. And then next slide.
I could take this one. Just to piggyback on what Referee Sidios was saying, we have seen an increase in filings to expunge rent escrows, or maybe civil other cases that are like housing adjacent. And again, because expungements are a legislative creature and the expungement law surrounding housing is limited to evictions, there is no legal authority to quote unquote expunge another type of civil or housing case. Attorneys or parties can request the court to seal certain documents or actions, and there's certain legal requirements and findings that are required before that happens. Essentially, there has to be a showing that the private interest of keeping the case or document non-public outweighs the presumption of public access. So to the tenant's right to court-appointed counsel, another big change from the 2023 session laws is the right to a court-appointed attorney in certain public housing cases. So the requirements are that the eviction action is involving public housing, that the complaint alleges breach of lease, a simple non-payment of rent case wouldn't qualify, and that the tenant is financially unable to obtain private counsel. One of the areas that may be causing confusion is that public housing is not defined in Chapter 504B. So judges may be applying it differently. I'm haven't quite seen a ton of these to really share any sort of pattern or establishment. What I have heard from tenant advocates that practice in this area regularly is that they see the term public housing to include not folks who are receiving Section 8 vouchers, for example, or receiving any form of government assistance. It would be the people who are actually housed in the public housing facilities. But we can talk about that when we get to the discussion part of the session today if other people have different experiences or thoughts. Next slide.
And then this slide just talks a little bit about the ETRAs, which is the Emergency Tenant Remedies Action cases. Those were always a thing, but the new laws in 2023, effective 2024, created a lot more sort of specificity, but also broadened the statute. So it gives us all of these specific sort of issues that people have with rental housing as examples of what could be an emergency tenant remedies action problem. It still has to be an emergency, and I would say that's kind of the one issue I've seen maybe more in this recently in 2024 is that maybe there's been more people filing under the ETRA statute because of this broadened definition, but whatever the issue is, maybe it wasn't actually an emergency, so it's really more of a rent escrow type of case. But that being said, the ETRA statute now includes like specific things such as serious infestations, um, loss of a non-functioning refrigerator, for example, and then if included in the lease, a non-functioning air conditioner, or if it's included in the lease, no functioning elevator. So those types of things were, whether or not they would be included as part of an ETRA were maybe a little bit unclear previously. And now the legislature has made it clear that these are the types of things that they would like the court to consider as an ETRA. Another sort of change to the legislature to the statutes is that tenants can also file an ETRA for privacy violations, which was not something contemplated previously by the statute. And the site for that is down there. It's 504B.211. Next slide.
I could talk a little bit about this. So a statewide implementation of the 2023 session laws included updating and creating new court forms. The link to the court forms are there. Among the substantially updated forms include the complaint. There's also that pre-filing notice form. If landlords are interested in using the court form, it's available. And then there's also an application to apply for a court-appointed attorney in those limited public housing cases. And then we also have something called court administrative processes. The short name for them are CAPS. And what these are the statewide guidelines on how court administration processes filings and case types. I did see a question in the chat, for example, about emergency tenant remedy actions and ex parte orders and hearings. So we do have a CAP that covers landlord tenant law and talks about how a eviction action, rent escrow, ETRA is processed. And the purpose behind the CAPS is to create consistency among all district courts so that if you're filing a case type in Hennepin, and then you file later that same case type in a different county or district, your case would be handled similarly. Now, there is no substitution for judicial discretion. So judges have broad discretion on how they manage their calendars and also how they um, make findings. So it can't always be the exact same scenario because every case and judicial officer is different. But as much as possible, both the forms and the caps are designed to create a similar experience across all districts. Some courts might have local forms. So if there is a statewide form, everybody's encouraged to use it, but there are some courts that just based off of their resources or how they have designed case assignments might have different forms or processes. So always check with your local district if you see a distinction between the statewide form and what they are asking for. I think this is the last slide, and I know something that Rachel was interested in learning about. So the housing court rules apply in Hennepin and Ramsey only, and they are found within the general rules of practice. That committee had created a work group following the 2023 session laws that we're talking about today to see what types of updates should be, must be, or can be made to the housing court rules. So that work group is still in the beginning to middle stages of reviewing it. But again, this work group is part of the general rules of practice. For those who are interested in kind of following where the general rules are going, what they're looking at, there are public filings and public notices on the court's webpage. I can share that link to with Rachel as well, so she can put it in the chat if you're interested in signing up to receive notices. Typically, if a rules committee recommends rule changes, it goes to the Supreme Court, and the Supreme Court, more often than not, depending on the substance, will offer the recommendation up for public comment and sometimes public hearing. So you would also receive notifications of that hearing date or the opportunity to provide comments by signing up for our public notices.
All right. Great. That was the last slide, Elizabeth. Well remembered. And yeah, I would love that link. And also the bill number, if you have that, because I have been tracking all of the bills, but at this point, what is ended up in what bill is kind of like the spider web that has been on the back of your slides. It's going all over the place. If you play Ticket to Ride, like a Ticket to Ride train snaking its way around the board. Thank you so much for all that information, both of you. Informative, very interesting to hear. A couple of points that I wanted to make really quick, just in case it wasn't clear. Hennepin County itself, where obviously referee Citios works, has by far the most evictions filed of any county across the state. And so kind of, you see it all en masse multiple times, whereas, some districts, some courts may only get, a handful of eviction hearings every year. Uh, Hennepin County is dealing with thousands in a month, so potentially. All right, so let me first and foremost, while Elizabeth is sending me, thank you very much for sharing all of that stuff. For the public notices about that work group. We are set. We have come to the questions section of everything. So we had some pre-submitted questions. I'm going to limit some of them to more specifically about court procedures and things like that. There are some questions that folks submitted, which I appreciate that. I'm just probably going to let you know that you'll need to contact Homeline directly because it's a more specific individual issue that would be more benefited from having a one-on-one conversation instead of in a large group session like this. All right. I think I've put enough qualifiers on that. So first and foremost, some of these will be a little bit of a repeat, but I want to make sure that if people had that question beforehand, that they really understand what the answer is now. So Susie is a service provider, and they're wondering for removing an eviction, so an expungement, is that still something that can be, is there a fee waiver that can be accompanied by that if you are a tenant who has to file that motion? So
Sure.
yeah, fee waivers still exist.
Yep. So there is a fee waiver form that was updated not too long ago to reflect some more plain language. And if you're receiving any government assistance, you don't have to fill out the entire form. So we're trying to make it a bit easier on court users. The legal term is informa pauperis. So in the alternative, we've been using fee waiver for more plain language. And yes, if it's your first filing in any civil case and you believe you qualify for a fee waiver, then you would submit that fee waiver along with your first filing. So if you're requesting an expungement and you've never paid the filing fee before, then you would want to attach the fee waiver at the same time that you are applying for your expungement.
Yeah, because otherwise the expungement, if you don't attach the request the fee waiver or you don't qualify for one, it does cost something depending on where you're at to have that looked at, right? if you have to
If
file the
there's
motion?
no motion, so there's filing fees and there's
Mhm.
motion fees.
Oh, sure.
So if there is no motion and you've already paid the filing fee, there may not be a motion fee assessed. So like that, there was that one slide that explained when no motion is required versus a motion.
Mhm.
But anytime it's your first paper ever filed, then there's a pretty hefty fee. And if you qualify for a fee waiver, then yeah, just submitting them simultaneously is the key, is what you want to file along with your fee waiver document. And if you've received a fee waiver but it's a year or older, you'll want to submit a new one because most fee waivers are just good for 1 year.
Gotcha. Awesome. Thank you. Um, so then, Elsa had just asked a very broad question about specific courtroom procedures. I think that is possibly something that we could spend a whole week talking about, depending on the courtroom. But they ask an interesting question about how are mediators being used. So if you guys can talk about some of those resources that might be available or not available, depending on where you're at.
So that varies a lot by district. I know in the fourth, we do have mediators available for housing cases. At this time, the way it sort of is working is that if parties agree that they would like to have mediation involved in their case, the referee, whoever's presiding that day, will issue an order sending them to mediation. We work with two different local groups for mediation, CRC, which is the Conflict Resolution Center, and then CMRS, which is Community Mediation Resources Services, I think.
Sounds about right.
I probably got that a little wrong, sorry. But they're both great organizations and they're very skilled in helping mediate housing cases. They also do other kinds of cases like harassment cases and things like that. But for housing purposes, they can help mediate and often have good success and good results with that. They will help tenants and landlords by writing down the agreements and even sending them into the court if folks don't have attorneys and need some help with that. I highly encourage everyone to go to mediation for a much speedier resolution to their issue. How it works in other districts varies. I know some districts do have mediators at their initial appearance calendars that are on site to mediate, or maybe not on site, but on Zoom to mediate immediately at initial appearance calendars. But there is kind of a wide variety of what's available out there.
Sure. And that's actually, I think, a good point is that Hennepin County is also doing your eviction hearings in person. You transitioned back to that a couple of years ago. While most of the state is still on Zoom. And as far as we can tell, and what we've heard, maybe Elizabeth knows more than I do, about that being kind of still the plan going forward is to remain on Zoom for the most part.
Yes, I am unaware of any intention for most civil cases to go back to presumptively in person. If it's an evidentiary hearing, then it's presumed in person, but otherwise it would be remote.
Sure. And referee studio, so you haven't heard anything about going back to remote, right?
No, I haven't. In Hennepin County, obviously, as you said, Rachel, we have the bulk of the filings in the state. And part of the reason that we are in person for our initial appearance calendars is just because they are so large with so many different cases on the calendar. In order for us to sort of keep up with the level of demand, we moved to in person about a little over a year ago now, so that we could sort of address the backlog issue that we had and also sort of stay on top of the number of filings that we were receiving. So we, I think, are probably the only district that is doing in-person initial appearance calendars at this time, but we have a special, I guess, exception to the general rule that those should be on Zoom.
Okay. Thank you. Okay. Megan, I see you. You give us a call directly about your eviction. We can talk about what your situation is. Um, so, oh, okay, Sarah is an attorney and they were wondering, are the courts requiring a written application for appointment of counsel in public housing cases?
I don't think there's a legal requirement for a written application, but I wouldn't be surprised if judicial officers require it. And court administration and folks at a state court administration prefer written applications because it allows us to gather statistics and really, get a sense of needs based on trends that the legislature, other government entities, and nonprofits will find helpful, not only the courts. So there's no legal requirement that it be in writing. Most judicial officers will require it to be in writing, and then there's a strong preference from court administration that something be submitted in writing.
All right. Fantastic. Thank you.
And there's a form for it too.
Ooh,
So,
okay. Is that on the regular court forms site or is that?
yep, yep.
Okay. All right, and I did put that in the chat here. So as you see in the chat, there's link upon link upon link. So hopefully if you need to scroll back through that, folks. So then, that was that one. So this is something that I have seen as well, and I not necessarily as much in Hennepin, but across the state, certainly, where in a housing eviction case, like you were talking about how some of the new rules, like there's a lot of boxes to check for landlords when they're filing. And there is some inconsistency about how judges and referees kind of handle it when a landlord has failed to check a box, whether through their attorney or through pro se filing. Um, how is that supposed to be handled? Is that it says, dismissed, but why do some judges give continuances? Obviously, you can't know what's going on in the other judges' minds, but there is an inconsistency that's happening across the state about how those things are handled. And I don't know if any of you can talk about that or to that.
Well, I can't speak to any specifics because I personally don't see it, right?
Yeah.
Because I only see what's happening in my own courtroom. But I would say that part of it may be just a education issue because we had so many changes that happened at the beginning of this year. We've certainly tried to get the word out to the judges around the state about these changes, but even for those of us who are lucky enough to practice or to work in housing court and to sort of be immersed in that law all of the time, it's confusing. There's a lot of changes and a lot of things are different now than they were 6 months ago. And so my guess is that if things are being handled differently in different districts, it's probably just either sort of a lack of knowledge or misunderstanding of what the new statute says, um, or genuine disagreement amongst judicial officers about how things should be interpreted could also be there because, with any statute, the language of that statute, that's, what lawyers get paid to sort of dig through and find problems with and, you know, uh, sort of explain and make sense to judicial officers, and those interpretations differ. So it really just depends on who you're speaking to and what the arguments are raised and that sort of thing as well. So
And as far as the statewide process on these eviction actions, um, it, administrators aren't going to dismiss the case without a judge's order, right? So if they fail to attach a written lease, or they fail to do the pre-filing notice, or they didn't strictly comply with the new statute, and that statute says the court shall dismiss if XYZ, because it says the court shall order the dismissal, there is no administrative authority, right, to just filter out these cases without a judge's review. And like Referee Sidious was saying, is there's individual discretion and there might be disagreements on how to interpret the statute. Um, and we do provide publications on housing changes, but we all were inundated in 2023. It was the biggest legislative session in 30 years, if not ever. So there's probably still folks unpacking changes not only in housing court but everywhere. I haven't heard of a trend one way or the other, um, but if there's something that consistently occurs and you think it needs to be addressed, you can always contact your county administrator, or there is a ability to email the state court administrator's office as well.
Okay. Yeah, that's a recurring theme if people have been watching our webinars for the last year of this is what the law says, but you know, it's all new, so we don't know necessarily how it's playing out. And so we're literally in the it's playing out right now. And so we're all kind of still sorting through what it means. And it's going to take a little bit of time for it to come to any conclusion, if ever. So thank you for that. Let's see, let's move on to Abby has a question. They're a service provider, I believe, about letters of guarantee. Now, these are, for folks who may not know, these are letters coming from usually agencies that are guaranteeing that they're going to pay a tenant's rent. How does that kind of play into a eviction action at this point that's been filed if a tenant is able to provide this letter of guarantee at the time of their hearing?
Well, the statutes changed on January 1st, and now it allows for people to redeem their tenancy with a letter of guarantee. This is sort of one of those areas, kind of like what we just touched on with the last question, Rachel, where there's a lot of ambiguity, I would say, in the statute about what qualifies as a letter of guarantee, what has to. There's no definition of what a letter of guarantee is, um, or sort of what the requirements of it are. But the statute does say that a letter of guarantee has to be accepted for redemption purposes by a landlord. So that is now on the books. And that's the only change in the statute regarding letters of guarantee. For several, since COVID, really, letters of guarantee have become sort of a very common thing, at least in Hennepin County, that we see with regards to people reaching settlement agreements. Oftentimes it'll be a settlement agreement that's contingent on getting a letter of guarantee for a certain amount by a certain date, that sort of thing. So they do factor large into our daily work. But that's what I know about letters of guarantee.
Awesome. Great, thank you. It's as you say, it's a relatively new, I mean, they're not new, but it's a relatively more common thing. So it's good to touch on those. All right, so the rest of these I'm going to say are more specific questions that are things that folks should either call us directly. Ronald, I see you about your questions about second chance for ex-offenders. I talked to our criminal person who also does criminal expungence here in the office, and she suggested reaching out to Amicus. They're a really great resource for you. We at Homeline don't handle criminal issues, so we're not a good resource for you in that case, but I will post that link in a second to the chat if you're on. Oh, and Charisse had asked about rent increase control being applied to other cities in Minnesota. That is a city by city basis. It's an ordinance in St. Paul that for rent stabilization restrictions. And so depends on the city you're in and whether they're planning on implementing one of those or not. So wanting then now to move on to some of the questions that we got during the session or during your presentation. I'm going to try and go through these in order just because of how we got them. So Daniel is asking specifically about ETRAs, where some courts don't necessarily understand the procedural governing about, you know, some courts are demanding rent as part of the court proceeding before they'll take the next step. So you made a link to, or I think I put a link into those caps that you talked about. So is there guidance for ETRA cases that can be shared if a lawyer or a tenant is in this situation that for example, we've got another one here in Ramsey County that's been waiting for 2 weeks for their ETRA hearing from when they filed. And so it's just one of those things that I don't know, the rules have changed a little bit as opposed to what is an ETRA-able, emergency, but how those rules are being applied is inconsistent. And so if there's a way that attorneys or tenants can send that information on to help get that process sped up, I guess.
Sure, yeah, the caps and the forms were updated, and there was a communication in our internal news kind of publication network. But similar to what we were saying before, with all of the changes, there might be some catch up, but I can definitely look into elevating the issue and see what can be done about a further or additional communication about the new ETRA statutes.
Hmm. Yeah, it's interesting what we've been seeing play out thus far this year.
Thank you for the feedback.
Yeah, I mean, all I would say is just, point to the statute, which I know is not super helpful, but 504B.381 describes how an ETRA is supposed to be handled. So that's where I would go when you're talking to your judicial officers about, what should be happening with that case. So.
Mhm. Um, JJ is wondering, so going back again to those, when you're filing the eviction complaint as a landlord, if the lease is verbal instead of written, how does that affect the regulation that requires the lease to be attached?
Yeah, so that's a good question. The statute talks about, if if there is a written lease, it has to be attached. Obviously, if there's not a written lease, then it can't be attached because it doesn't exist. And so that would be, generally speaking, a question that would come up at the initial appearance. If there's no lease agreement attached, as a judicial officer, I'm going to be, sort of looking through the complaint to try to figure out, is there just no lease, or is there a lease and it just wasn't attached? And sometimes your judicial officer may ask you questions about that at your initial appearance, but clearly if something doesn't exist, you can't make it exist, so you don't have to attach it.
Sure. All right. So we kind of talked about Jessica's question. So there's some, all right, we talked about expungements. So applying for expungements today, obviously there's the non-motion things and then there's the motion upon motion. There is a question about whether um, the, I'm trying to formulate this into something that's not just a calendar issue, but so if it's clear that the tenant, the eviction was from 4 years ago, is there anything else that that's a mandatory expungement? So it's just like eviction happened, is it from the date of filing or the date of judgment? And is it something that's just like essentially rubber stamp, like, oh, yep, that was from 2020, we'll just immediately expunge it. And then my follow-up question to that is, how long does it take then to fall off the record?
I can answer that, and then Referee Cios, please chime in if there's anything different you'd like to say. So the 3-year expungement law applies to evictions granted on or after January 1. So if you're applying for an expungement solely based on that, then it would be before a judicial officer and it may or may not be granted. Because as one slide indicated earlier, there is inherent and discretionary expungement. So a judicial officer may find in the interest of justice your expungement can be granted, even if it hasn't been 3 years from the date of the eviction granted. It's kind of similar to what I said earlier. There is a misconception that anything that's over 3 years old is going to disappear. It won't without a court order or until the law changes or until they're destroyed as resources are available to state court administration to do that. Um, so how long it takes, it I think it should be done within 30 days. Um, and if it takes longer than that, I would reach out to the court administrator again to see the status of the eviction action. Another thing that is noteworthy is if there is a money judgment in the case, that money judgment is good for 10 years. So you can't expunge a case that still has a money judgment that's supposed to be good for 10 years. That's pretty rare. The last that I looked at the stats, there was, I think, less than 7% of eviction actions have money judgments. Typically, a landlord will file a separate action if there it is some sort of money issue. But that's another thing to keep in mind is if you have an active money judgment on your eviction case, that might prevent it from being expunged under the mandatory expungement laws.
Gotcha. Referee Studios, you had said that you were getting lots of expungement requests every day and through your court. Do you have any sense of how many are being sent?
That's a good question. I don't have any like formal statistics on it. I'm just trying to think sort of anecdotally. I could tell you probably in a given day, at least 20, I would say 20 to 25 are
Okay.
received in Hennepin County. There's occasionally a slow day, but usually we get quite a few. Um, and kind of back to what we were saying about language choices of the legislature, with regards to the mandatory expungement and the 3-year requirement, one of the things that we've sort of struggled with is that the language of that statute says that three mandatory expungement for 3 years after the eviction was ordered. And so we are getting occasionally requests for cases to be expunged that didn't have an eviction ordered. So, for example, somebody settled the case 3 years ago and there was no eviction. So these are the kind of language issues that can sort of hang judicial officers up in terms of maybe what the legislature intended for something to happen didn't quite happen exactly as they intended it because of the way the statute is worded. And I think, to Elizabeth's point, like we're all just kind of, wading through this and trying to figure out how it works. And it's not necessarily a one size fits all kind of answer. It is an individual inquiry into each case. We're going to look at each set of facts and make a decision based on that. But we do get a lot of them, and we do grant a lot of them. So that's all I'll say about that.
Gotcha. Sounds good. Yeah, presumably, if you have consistently the most evictions filed in your district, then it also is probably true that you also have the most expungement requests in your district as well. So, all right. Thank you. Let's see. Public housing was already talked about. The specific definition isn't in 504B. And then Elizabeth did include the bill number that we're talking about for some of the language updates. The housing omnibus bill is Senate file SF 3492. I believe it's being heard in the Senate floor tonight at some point, or early tomorrow morning. They're at their point in the session where they're kind of pulling all-nighters because they have to be done with business by midnight on Sunday. So they got a lot of work to do in about 4 days. All right, so that's done. Jessica is an attorney, and they're wondering if we have concerns about language included in a statewide court form, who can we reach out to about this? Is there a contact information for the state court admin council?
So there is no formal avenue on providing feedback on statewide forms, but there is avenue to provide general feedback. So let me get back to this group with an answer to that. I can talk a little bit about the development of forms in general. So there is a forms manager that is part of the self-represented litigant program team. And then there is a committee that reviews forms. So it's a very robust process, which sometimes doesn't mean that it gets done quickly. But there's representatives from every single district as part of this committee, and there has to be a majority vote before a form can be published online. So stay tuned on who you can contact for feedback.
Okay, thank you. All right. Thank you for that. Anonymous is wondering, how does the 4th District fund mediators? Do you fund mediators if they're at those housing court sessions?
So that's a good question. I know that we do have contracts with the mediator organization so that they provide services at free of charge to folks that have cases in the 4th. Beyond that, I don't know much about that process at all in terms of like how that happens. I just know it happens. But maybe Elizabeth, do you know anything about the mediator contracts?
I'm not one of the contract attorneys on the team, but I do know that there is no statewide contract for mediators in housing court, so it would be county/district specific.
All right, thank you. And so Anonymous is asking again about in-person versus Zoom hearings. How does in-person speed up the process and helping get through the backlog?
So that's a good question. What we were finding on Zoom is that we would kind of max out in terms of the number of cases we could hear in a morning or afternoon session at around 20. In person, we're hearing about 35 cases on a calendar. So it's not, it's not a sort of a huge difference, but it is a difference. And the issue, particularly in Hennepin County, is that most tenants are able to get representation at this point through adult representation services or through legal aid or through VLN, or they are also able to get financial sort of assistance sort of on the spot by calling into the county from the courthouse. And those things were difficult to do on Zoom. They weren't impossible. We did it for 2 years. So it's definitely possible. It's just in terms of the volume, we weren't able to keep up with the new filings, and also have everybody get access to resources in the way that seemed, that needed to happen. And so that's why Hennepin went back to in person.
Yeah. Hennepin has a fairly unique setup as far as how when folks show up for housing court, like what resources are actually like there to be had. So it's I won't say it's a joy to advise folks who are going to housing court in Hennepin County, but it's the fact that there are a lot of resources that are available the day of is a helpful for, I think, everyone involved, whether you're a tenant or a landlord, because hopefully it's more of a one-stop shop is what I'm hearing for folks, for just getting these issues resolved quickly. So it's, I'm not saying it's a clinic, but it's a really, when you walk into housing court, there are a lot of resources there that folks can utilize. And so it's unique. Ramsey has something sort of similar, but they're on Zoom still. I don't know of any other counties or districts that have anything quite the same scale as what Hennepin does. So that actually segues into a question that I had from someone else here at Homeline. Because Hennepin County has so many eviction filings and housing court issues, rent escrows, ETRAs, beyond just evictions. Do you get a lot of questions from other districts asking you, probably you specifically, Referee Cedillos, about how do we handle these things? Like, do you do trainings? Do you just get an email being like, what is this from other judges?
Yes. And yes,
Okay.
I do. So I get questions, and also, we do trainings, specifically with regards to all of these changes that started in 2024. We did trainings for all the judges regarding these things, although to be fair, we were doing that training in December before the changes actually took effect. So a lot of what we were telling the judges at that time was our best guess of how these things would play out. I think we'll probably do an update to that now that we've seen sort of more scenarios on how this is playing out in the real world. But yes, so the answer is yes to all of those things.
Okay. Thank you. All right. So regarding letters of guarantee, what about this person is saying, what about landlords who will not provide the necessary W-9 or ledgers? Basically, from the court's perspective, the letters of guarantee are outside of what the court is dealing with. So my response to that is that there is no legal obligation for a landlord to participate in those programs. So it often is the best, I would say it's a good business practice, is my opinion about, if you want some money, participating in those programs helps get that money to you as a landlord, but there's no obligation that you participate with that. So if the landlord's just not willing to work with it, then that's what it is, unfortunately. So let's see, we did that one. You guys have some really great questions. We are at, I see 2:42, so we still have about a little over 15 minutes. So if you want to take a breath, I'm going to continue looking through those. I know this is kind of a, really, really appreciate you making yourselves available for all of this, all of these questions. So let's see. So there's a lot of questions, obviously, about expungements. And so I know that there's some language that's hopefully going to be the legislature, there's confusion about it. And so Anonymous is asking specifically if I apply for an expungement today, how is it applying the law backwards in time? Specific, that they're questioning, it sounds like the interpretation of backwards in time. I think we have, discussed that to an extent, but at this point, that's the interpretation the court has, and we'll wait to see what the legislature does in the next 4 days, is kind of what I'm hearing from Elizabeth, at least.
Well, and I don't want to speak for every judicial officer, like like Referee Cedillos, that there might be different views, but I just wanted everybody to know that administratively, the branch isn't able to to wave a wand and everything go away. It'd have to be pursuant to court order.
Mhm.
And that I think there might be judicial officers out there that are expunging cases that are 3 years old, and it may be pursuant to that line in the statute, or it may be based on inherent authority. But as far as how statewide is applying it, it would be January 1 going forward until the law changes.
Mhm. Gotcha. Thank you. So I've seen a couple of questions go by about, this might be getting a little in the weeds as well for some folks, but there's the MNDES, or the Minnesota Document, I don't actually know what the E stands for, system. MNDES is what I always call it, that some tenants have to upload documents and exhibits to that before their initial hearing, and some of them get to wait until after their initial hearing for a trial. It kind of depends on where you're at. And so is there, I guess, is there supposed to be a consistency from court to court with that process?
The acronym is MINDES, that's how we say
Ooh,
it.
okay.
Minnesota Digital Exhibit System. And it's really supposed to just be a conduit for exchanging exhibits between the parties and then also submitting them to the court. It's not a substitute for trial orders, for example. So yeah, you could have a judge who is ordering them to be submitted ahead of time versus later, or the timings might be different. So that's all based on the trial judges or the hearing judge's preference. So that might be why
Mhm,
there's a little bit of inconsistency because of the orders in the specific cases.
mhm. So yeah, basically read your court paperwork carefully. That's always
Yeah.
just a good sound advice, is read the paperwork carefully. Um, and I know you had put this somewhere else, but there is no fee for filing anything in Mendus when you're uploading exhibits. So, da, 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 da. Ooh, we are getting into some really long questions here. I am sorry. Um, if I take a second to read this one. Um, okay, interesting. I don't know how to answer this one. Sorry, this is about court-appointed attorneys, and how clearly it has to be to the um, that to the tenant and to the attorney and everyone involved, like that they have a court-appointed attorney versus like a volunteer attorney. Like how clearly does that have to be? Like, do you get a little name tag that says court-appointed counsel? You know, or your Zoom name gets changed. How does one identify that they've been given court-appointed counsel?
I think this goes back to why it's important to have a written request and a written order. There's the written request and the written order templates that are out there are very detailed on like how you're going to get paid, how all of that good stuff, including making it clear that you are a court-appointed attorney.
Sure.
So yeah, I don't know how to answer the specific question other than maybe it's a lesson and put it in writing and file it in the case.
Yeah, that's way beyond what my expertise is in. So yeah, if you find out, let us know. Share around. Um, so then um, Patricia is asking, just trying to make sure I heard correctly, in a situation where defendant is requesting mandatory expungement based on agreement of parties, does the defendant have to pay a court filing fee or seek a fee waiver? Yes. That's, yeah, there is, yeah, court fees. Tim asked a question that I don't know the answer to either, and I don't know if you two are able to talk to this or not. But Tim is wondering, what is the basis for denying expungements when there is a money judgment? The expungement statute does not place this condition on expungements.
So I'm not a judicial officer with a request for expungement before me, but I can
Sure.
tell you that even though Chapter 504B might say that there's mandatory expungement, there's another law that says that money judgments are good for 10 years. So you have conflicting statutes, and how judges are going to apply those conflicting statutes might be determined on the facts and their discretion. But I'm just sharing here today that there is a law that says money judgments are good for 10 years, and you can't have a money judgment if you've also expunged the case. So there's a legal right to have your money judgment good for 10 years, and then there's a legal right for expungement. How that interacts is going to be up to the judicial officer, or maybe the Court of Appeals or the legislature someday. We'll see.
That is the joy of having a 3 branches of government, is that they're always kind of piling on top of each other to try and work out what is meant by what was said, or what, what that's not what we meant, this is what we meant, and constantly working that out. So we are in hip deep in that process right now. So yeah. Let's see. Jessica also was asking about steps to you would recommend if a judicial officer still indicates they aren't willing to schedule any trials unless rent is posted to the court.
Is the question, what do we do if that's the,
Yeah, what steps would you recommend if a judicial officer still indicates they aren't willing to schedule any trials unless rent is posted with the court?
well, I know this is kind of a broken record, but I would refer them to the statute. I would just, sort of tactfully point out that the statute doesn't allow, at least it doesn't allow for them to require past due rent to be deposited. It does allow them to, if the trial is going to be more than 10 days out, it does allow them to require ongoing rent to be paid into escrow or into the court. So, how you do that, I don't know. But basically, I would just go back to the statute and remember judicial officers are humans too, and they have different sort of levels of comfort with all of these changes that have happened. So it could be that they're just not familiar with the change to the statute, or something. I don't know, but I would just refer them back to the statute and advocate for your client as you always will.
Yeah. And just a good rule of practice, of course, Jessica, I know you know this, but making sure that you make that argument for the record so that if you do need to refer back to it, it's there. If there is need of it later on in an appeal or something like that. Okay. Anonymous again, and I don't know if this is all one anonymous or if these are multiple anonymous. The beauty of being anonymous, we don't know, but they're wondering about a failure to accept assistance from an agency, discrimination based on source of income from the landlord's part. That is something that not necessarily. Discrimination issues are more complicated than the failure to accept assistance. The tenant's obligation to pay rent is their obligation, and how they get their money is, that's their point. So the rules are really more about denying housing. And that is also something that is actually up at the legislature, or was up at the legislature this year, about source of income discrimination issues. So that is a different topic for a different day. Be happy to discuss that more. So, or you can talk to the Department of Human Rights about that. But we are going to, yes, there is more than one anonymous. Thank you. We've cleared out our questions. So well done, everybody. That was quite a marathon. We've got 7 minutes left. So I applaud you again. Thank you so much for taking the time to be here today, for sharing the information. Anything else that you want to use a minute or so to say? I can give you the floor. I'm going to post our tenant information, our hotline, our contact information here for Homeline. If you are a tenant who has questions about specifically your rights, please give us a call or email us, and we can talk about your specific situations.
Thanks for having us, and thanks for everything this group does.
Absolutely. Thank you all then very much. Again, we'll get this posted to our website shortly, but have a great rest of your day and hope you stay well. Bye now.